Welcome to our webinar on fundraising and investing in the USA. I'm Fabian Oyhus, an associated partner in the fund formation practice of Schnittger Merman Partners, and will be hosting this webinar today. I've been advising German sponsors of private equity, venture capital, and fund of funds on their fund structures and international fundraising for more than 10 years. Today, I'm very glad to be joined by two proven experts from the renowned law firm Debevoise & Plimpton, Kenneth Berman and Gregory Larkin. A very warm welcome to both of you. To get started, I would like to say a few words on your firm and on you two, Ken and Greg. Thereafter, I would like to shortly introduce today's topic, and then the stage is all yours, Ken and Greg. Debevoise & Plimpton is a premier law firm with market-leading practices. Approximately 650 lawyers work in 9 offices across 3 continents in a wide range of practice groups. Your private equity funds practice is one of the largest in the world. Kenneth Berman is a partner of Debevoise & Plimpton for many years. Ken focuses on regulatory issues in connection with investment management, particularly for private investment funds like venture capital and private equity funds. You're recognized as a leading lawyer by Chambers USA and recommended by Legal 500 US. Ken also has an in-depth knowledge of, let's say, the dark side of regulatory requirements, because prior to joining Debevoise, he was an associate director at the SEC, the US Financial Markets Regulatory Authority. Also with us is Gregory Larkin, who's a counsel at Debevoise and also a member of the firm's investment management group. Greg focuses on providing regulatory and compliance advice to financial services firms, in particular investment advisors and sponsors of private investment funds. Ken's and Greg's clients include such renowned firms as AXA, Apollo, Carlyle, EQT, HarborWest, and KKR. Thank you both very much for presenting this webinar for our audience today.
Thank you, Fabian, for that. Oh, sorry.
Yeah, we had the idea for this webinar when we learned that more and more of our clients are considering increasing the exposure to the US. Most venture capital fund managers already fundraised in the US for many years, but now more and more of our clients are also regular visitors to the US doing investments there. Some even found it such a lovely place that they decided to set up shop. In the next few minutes, we will discuss the most relevant issues that those managers are faced with from a regulatory perspective. This, naturally, does not cover everything one would need to know and does not provide any guidance for any particular case. Also, we will not touch up on the very important topic of US tax issues. However, I believe that we will get a very good first impressions of the questions such managers will have to be dealing with. And now over to you, Ken and Greg.
Okay. Thank you, Fabian, for that very warm introduction. Today, as Fabian said, we're going to be focusing on regulatory issues that are faced by fund managers who are either planning to invest their portfolios in the U.S. or more particularly are looking to raise capital from United States investors. And our primary focus today is going to be on really 3 regulatory areas. And let's go to the slide that provides just the general overview. First, we're going to be focusing on the regulatory framework applicable to the funds themselves. In other words, does the fund have to register as an investment company under the United States Investment Company Act? And if not, why not? And the answer, as we'll find out, is going to be the fund can be structured in a way to avoid what is really very onerous regulation under the Investment Company Act and rely on one of 2 exemptions. The other area that we're going to focus on is the actual fundraising process. That is, does the offering have to be registered under the United States Securities Act of 1933? Does there have to be a registration statement filed with the U.S. Securities and Exchange Commission in order to offer the securities? Again, we're going to be focusing on the exemptions that are available under the Securities Act of 1933. And those exemptions, by the way, are incorporated into the investment company exemptions that we'll be talking about. And the final area that we'll be spending some time on is whether the persons, whether it's the manager, the general partner, however that person is characterized, whether that person has to register under the United States Investment Advisors Act. This is actually a fairly complex area. There are exemptions available, but some of the exemptions will require filings to be made with the SEC, and we'll be addressing that in the third section of the regulatory overview. Once we've gone through that regulatory framework, we're going to turn to various scenarios that we think European fund managers will run into in terms of trying to determine which of these regulatory frameworks may be applicable to them or the funds they're raising. First, let's turn to the Investment Company Act. As I said, the Investment Company Act is really designed to regulate public funds, but it can be triggered by any company that's an investment company. And let's just assume for the moment that a venture capital fund or a private equity fund would be viewed as an investment company for this purpose. Well, how does a venture capital fund or an investment or a private equity fund avoid being subject to the fairly burdensome requirements of the Act? There are one of two exemptions that are traditionally relied on. The first is Section 3C1, and that's available to a private fund that is not engaging in a public offering of the interest that the fund would be offering, whether it's a limited partnership interest or a limited liability company interest, and its securities, other than short-term paper, are beneficially owned by not more than 300 persons. This exemption was part of the original 1940 Act, which was obviously passed in 1940 when private funds were not really a significant factor in the securities market. While many funds relied on it for many years, obviously, it didn't provide a lot of flexibility for fundraising. In 1996, a new exemption was enacted, Section 3C7 under the Investment Company Act. And again, that's available where, one, there's no public offering of the fund being undertaken, and two, interests in the fund are owned exclusively by qualified purchasers. And qualified purchasers, in the case of natural persons, are people who own $5 million or more of investments. And there are rules adopted under Section 3C7 that provide a fair amount of detail as to what types of assets constitute investments for this purpose. It's not limited to securities. In the case of an institution, the institution has to own at least $25 million of investments. There are other provisions dealing with who can be a qualified purchaser that turn on familial relationships that we're not going to get into today. But that exemption, Section 3C7, is really the major exemption that's available for private equity fund investors. Again, primarily because there's no numerical limitation. Notwithstanding that, Section 3C1 is an exemption you should still be familiar with, because it often provides flexibility. It provides flexibility for a parallel fund, for example, that you may want to offer to family members, friends of the firm, or other investors that can't meet the qualified purchaser requirement. The two exemptions work in parallel so that basically you can have a fund that relies on 3C1 and a fund that relies on Section 3C7. I'll just add that there, under various no-action positions, if you have a fund that is, for example, organized under non-U.S. law, such as Cayman law, traditionally only the U.S. investors in that fund, if it's relying on 3C7, would have to be qualified purchasers. That Cayman fund can have non-U.S. investors who are not qualified purchasers, but there's some fairly complicated conditions attached to that approach. The second area that we'll focus on is the Securities Act of 1933. And the 33 Act, as it's often referred to, regulates offers and sales of securities, including interest in private equity funds. Under the 33 Act, offers either have to be registered with the SEC or exempt from registration. And as I noted above, in order to be eligible to use the Investment Company Act exemptions, whether it's 3C1 or 3C7, the private fund may not make a public offering of its securities. Private funds marketing in the U.S. typically rely on the private placement exemption provided by Section 4A2 of the 33 Act, and in particular, a rule under that section, Rule 506B of Regulation D. Among other things, 506B prohibits a person or a fund relying on this exemption from making any form of general solicitation or general advertising in connection with the offering or sale of its securities. And it is customary for the fund or counsel to the fund to obtain representations from the fund's manager or placement agent that they haven't engaged in any sort of general solicitation. This is important. This means that basically you can't engage in any advertising, public advertising in connection with a 506B offering. The placement agent or the fund manager can't approach persons with whom it doesn't have a pre-existing relationship to solicit their interest in the fund, or at least do so on any what I'll call mass mailing or blast email basis, because those types of communications might be viewed as a general solicitation. Similarly, talking to the press about the fund offering or sponsoring or speaking at public seminars about the fund offering might also be viewed as general solicitation. So it is typical for counsel to give advice concerning the types of communications that can or can't be engaged in connection with the 506B offering, but they're very limited, and it's basically designed, as a practical matter, your offering efforts may be limited to one-on-one presentations with investors or presentations with groups of investors with whom you have a pre-existing relationship. A few years ago, at the direction of Congress, the SEC adopted Rule 506C of Regulation D that actually does permit issuers to engage in general solicitations in connection with what are otherwise private offerings. Funds that are relying on Section 3C1 or Section 3C7 can rely on 506C as well and make general solicitations. But in our experience, very few private funds have relied on this general solicitation provision. One reason is they simply don't need to, because the basic market that they're focusing on, institutional investors, really are expecting direct communications. The other is just concerns that a general solicitation in the U.S. might create problems for the fund in connection, if it's going to be raising money in Europe, and the status of the general solicitation in the U.S. May create uncertainties concerning its European offerings. I'll also point out that there's a provision under the 33 Act, Regulation S, that basically is a safe harbor that provides what I'll call an exemption from registration for offerings that are made outside of the United States. And some private funds, even if they're sponsored by a U.S. manager, they're foreign funds, which in this case would mean they're funds organized outside of the U.S., may engage in offerings that are exempt from registration under Regulation S. Having said that, however, a fund that's organized in the United States, say under Delaware law, really can't rely on Regulation S because that might be viewed as a public offering for purposes of Section 3C1 or 3C7, and therefore it would not it would make it ineligible for the exemption. So if the fund is organized under Delaware law, its offering, whether in to U.S. investors or European investors, is going to be relying on either 506B or 506C. I'll just touch on the other conditions for a 506B offering. The first is that, as I said, there's no general solicitation or advertising. The second is the nature of the investors who are purchasing in the offering. As a practical matter, the purchasers have to be limited to accredited investors. These would include a corporation, LLC, or other type of entity that has total assets in excess of $5 million, or an individual who either individually or jointly with the individual spouse has a net worth in excess of $1 million. There are also additional thresholds that are available that are based on the individual's net income. Now, if you think about Section 3C7 funds, you would think that if you're limiting the offering to qualified purchasers, that is individuals who have assets of $5 million, the accredited investor definition might be viewed as being surplus, that it really doesn't add anything. But the measures are actually quite different. So if you look at subscription agreements for private funds that are relying on 506B as well as 3C7, there will be questions that are designed to determine that the purchaser is both an accredited investor as well as a qualified purchaser. In addition, the accredited investor definition is obviously very important if you're raising a fund that's relying on 3C1, where you don't have to meet the qualified purchaser threshold that's in Section 3C7. Securities that are sold in reliance on 506B are restricted securities for purposes of the 1933 Act, which is to say that their resale, the ability of the investor to resell those securities will be limited to a certain extent. Now, as a practical matter, the general partner of a private fund is going to impose resale limitations for other business purposes. In the case of a fund that relies on 3C7, they're certainly going to impose limitations on resale to assure that any person who acquires the shares in a subsequent sale is also a qualified purchaser. So there are limitations on the transferability of private fund securities. Another important condition, which was implemented in 2013, basically limits the ability of an issuer to rely on Rule 506 if that issuer was, for lack of a better term, a bad actor. That is, if the fund or certain of its affiliates engaged in conduct that resulted in sanctions under various laws, including criminal laws, settlements with securities regulators, and so forth, those persons are ineligible to use Rule 506 unless they obtain a waiver from the SEC. Now, if the person is subject to Rule 506D and is disqualified from relying on Rule 506 and is unable to obtain a waiver from the SEC, then that fund can still proceed with a private offering based on Section 4A2. In other words, Rule 506 is a safe harbor. You can still use the exemption that's available under the statute, Section 4A2. However, that can be a cumbersome exemption in terms of the process you use to determine whether the investors are are adequately sophisticated to acquire shares in a public offering. It may also subject the offering to review by various state regulators in the United States, and that can be extremely time-consuming. So while there are private funds that do rely on Section 4A2 for this reason, as well as others, the process of offering fund shares in the U.S. will be much more efficient if you're in a position to rely on Rule 506. And the final point I'll make is that there is a filing that is required to be made by issuers that rely on 506. It's called a Form D filing. It's required to be filed electronically with the SEC no later than 15 days after the fund's first sale of securities. It can be required, there are requirements that it might have to be updated subsequently to that. It's not a particularly cumbersome requirement. It's not a form that is typically reviewed by the SEC or by other regulators, but failure to file the form, while it doesn't result in the loss of the exemption, would be a violation of the rule, and that can have significant consequences thereafter. With that, I'll turn it over to Greg.
Just maybe on that, on that point of the Form D filing, isn't that also something which exclude doing further private marketing, so that you really do file it only after the last sale of securities?
No. You okay. Can continue to market securities and amend the form as required by the form from time to time, but that the fact that you've made the filing that's required to be made after the first sale doesn't preclude you from further marketing.
Very good.
And the filing of the form, it's interesting. It's publicly available, but merely filing your form, which would let the world know that you're offering this fund, wouldn't be viewed as a general solicitation since it's required by law.
Thank you.
All right, now I'll turn it over to Greg, who will discuss the Investment Advisors Act.
Thank you. So the last significant statute we're going to cover is the Investment Advisors Act, which regulates investment advisors. So in the private fund context, we're talking about the general partner to the private fund, the manager of the private fund to the extent it has one, and also any advisor or sub-advisors that provide advice with respect to that private fund. So all of those would be considered, well, usually considered investment advisors in this context. The way the Advisors Act is written is very broad, so it could capture anybody who touches the U.S. in any sort of way. But in practice, it's much more limited, and we're going to walk through the exemptions, in particular the foreign private advisor exemption, which limits the pretty broad scope of what the Advisors Act could touch on. So, just waiting for the definition of an investment advisor has four key elements. One, the person has to be providing investment advice for compensation. So if the advisor is only providing it for free, and that means also you can't be reimbursed for costs, then you're not an investment advisor. You have to be engaged in the business of providing investment advice. That means you have to be doing it on something of regular basis, but that is generally considered a very low bar. So anything other than very sporadic and non-recurring advice would be considered to be in the business. You have to be advising others. So if you're only providing advice to yourself, so if you're an entity, if you're providing advice to yourself, the entity, and wholly owned subsidiaries or affiliates of the entity, that's usually not considered another. But if you're providing advice to anyone else, even if it's just one person, then you're an investment advisor. And then the last element is you're providing advice to the securities. So it's both as to whether to purchase or sell a security, but also as to the value of the securities. Just a couple points on the definition of investment advisor, particularly as it relates to the European context. The U.S. Advisors Act does not distinguish at least within the definition of investment advisor, between the discretionary and non-discretionary investment advice. So, for example, a manager or general partner who's in charge of actually executing the transactions, that's investment advice, but also an entity that provides advice to the manager or general partner, that's also considered an investment advisor because they're providing advice even if it's on a non-discretionary basis. The client, so first off, in the fund context, the client is the fund. It's not the investors. So you're providing advice to the fund. So the client is the fund. But also, it's not necessarily limited to contractual relationships. So, for example, if the manager or the advisor has a contract with the general partner to provide advice with respect to the fund would still be considered the client, even if the contractual relationship runs to the general partner. That can be very important for these exemptions, but also in other contexts as well. There are a variety of exemptions under the Advised Act, but we're going to focus on three that show up as the most important in the private fund context. The first is the foreign private advisor exemption. The second is the private fund advisor exemption, and the last is the venture capital fund advisor exemption. The foreign private advisor exemption has four elements. One, you have no place of business in the U.S. Two, you have fewer than 15 U.S. clients or U.S. investors in your private funds. Three, the assets under management attributable to those U.S. clients and investors is less than 25 million. And four, you don't hold yourself out generally to the public as an investment advisor, unless you don't manage any U.S. registered funds, but we won't really get into that. The key points here: one, place of business. So it's not just limited to a formal office. So if you have an employee who regularly engages in investment advisory activities in the U.S., even if it's not at a formal office, that could be considered to have a place of business. And then the 15 clients and the 25 million, it relates to U.S. persons. So it's if you have a fund organized in the U.S. or if you have a investor who's resident in the U.S., then that would count to this. Regulation S relates to residency, not citizenship. So if you have a U.S. citizen, say in Germany, who's resident in Germany, that is not a U.S. person for this test. For this purpose, it would be only people who are resident in the U.S. But on the flip side, if you have a German citizen who's resident in the U.S., they would be counted towards these limitations.
Just as a practical matter, I think it's been rare that we've had experience with an entity that sought to rely on that exemption because of both the numerical limitations and the assets under management limitation. And particularly if you're planning to make any fundraising effort in the U.S. that's basically worth doing, presumably you're going to want to raise more than 25 million. So this exemption, while it's good to know about, I think is rarely relied upon.
Well, yeah, rarely relied upon by people who want to engage with the U.S. It's for people who don't touch on the U.S., it's used a lot. The second one, which is heavily relied upon for people who raise money in the U.S., is the private fund advisor exemption. This exemption is different for a advisor whose principal place of business is in the U.S. versus outside the U.S. We're going to focus mostly on the outside the U.S. because that's one easier to comply with and also, I think, more applicable to this webinar. So for an advisor whose principal place of business is outside the U.S., the conditions are: one, the advisor must have no U.S. clients other than private funds. So that means that they can't provide direct advice to any U.S. person who is not a private fund. So that means they can't have any retail clients that are U.S. persons. They can't have separate accounts that are U.S. persons, and they obviously can't provide advice to U.S. Regulated funds, whether it's registered funds or BDCs, business development companies. Second, the assets that they manage from a place of business in the U.S. must be less than 150 million. So the second point is very important. So if you don't have a place of business in the U.S., effectively it means that you can raise an unlimited amount of money from U.S. persons into your private funds without having to register, and you can rely on this exemption. If you do open up a U.S. place of business, it becomes quite a complicated and facts and circumstances determination as to determine how much you manage from that U.S. place of business, and that will go to how senior the people are, where the investment decisions being made, and other issues like that. If it's a relatively minor office, then you may still be able to rely on this exemption, or if they have a very limited scope of what they manage from the U.S. But it's really important that for the vast majority of non-U.S. advisors relying on it, most of them don't have a U.S. place of business, and so they can raise as much money as they'd like in the U.S. as long as that money is going into a private fund, whether a private fund organized in the U.S. or outside the U.S. It can't be into separate accounts.
Or they open up an office in the U.S., but the activities of the people in that office are so circumscribed, they may be limited to due diligence activities, for example, but all of the decisions, all the investment management decisions are being made from an office outside of the United States. To illustrate a problematic scenario, sometimes you'll see situations where you had an office that was opened in the U.S. to engage in due diligence activities, and then for any number of reasons, a member of senior management, or maybe not so senior management, but is involved in the investment activities, decides that they want to relocate to the U.S. At that point, you really have to make another determination as to whether any assets are being managed from that office in the United States, or whether there's a way you can structure the activities of that person such that if he is engaged in asset management activities, he does so from outside of the United States. It can be a very complicated issue, and as we'll find out, in some cases, the manager may wind up registering that U.S. entity under the Advisors Act, and we'll get to that in a few minutes.
Right, yeah. So I think the last bullet point on the slide raises something we'll touch on more detail, is how do you deal with having a U.S. affiliate and a non-U.S. entity, and whether the non-U.S. entity can rely on the exemption while the U.S. affiliate registers. We'll cover that in more detail in just a few slides. So an advisor relying on the private fund advisor exemption is what's called an exempt reporting advisor. That means the advisor is still not registered with the SEC, but they're subject to certain requirements, principally that they make a filing, which is Form ADV. It's not the complete Form ADV. It's just a partial part of the Form ADV. And then they make annual updates to that Form ADV. And then they're subject to the anti-fraud provisions of the Advisors Act, and also the pay-to-play rule, which relates to political contributions and solicitation of U.S. state and local government entities. It doesn't apply to, say, non-U.S. government entities. They are also technically subject to SEC examination, although the general policy of the SEC is that they don't subject exempt reporting advisors to regular examinations like they do registered advisors, but they may perform examinations if they're aware of or are tipped off to a regulatory concern. So this is something more significant than an advisor that relies on the foreign private advisor exemption, which doesn't have any filing requirement. But it's relatively light in the sense that it's mostly just a filing that you have to do within 60 days of relying on the exemption, and then every year just to make sure that the information is accurate. The next major exemption is the venture capital fund advisor exemption. This is generally an advisor exemption for an advisor who provides advice solely to one or more venture capital funds. There is no real difference for U.S. or non-U.S. advisors, so this is somewhat harder for a non-U.S. advisor to rely on than the private fund advisor exemption, because for the venture capital fund advisor exemption, it means that all of your non-U.S. clients also have to be venture capital funds. The private fund advisor exemption only limits who your U.S. clients can be, which is they have to be all private funds. Venture capital fund advisor says all your U.S. and your non-U.S. clients have to be venture capital funds. The rule includes a pretty strict definition of what is a venture capital fund. Not all funds that may consider themselves venture capital funds will meet this definition. Just going quickly through the requirements, because I don't think we'll spend too much time on each one. First, the fund has to represent itself as being a venture capital fund that engages in a venture capital strategy. Two, it has to limit its investments. So essentially, 80% or more of the investments have to be in certain qualifying investments, which are usually equity investments in private companies, which there hasn't been a leveraged buyout acquisition strategy. So, and it is not itself a private fund. So this would be what you typically think of your typical startup company or early stage company, which the prototypical venture capital fund might invest in. But there are types of investments that venture capital funds might engage in, like debt securities or other types of investments that would not be permitted in this 80% bucket. There is the 20% which you can make non-qualifying investments, but that's relatively limited. So again, some venture capital funds may not satisfy it. There's a limitation on how much the fund can borrow, which is at 15%. But again, usually that's not an issue for most venture capital funds who don't borrow too much at the fund level other than subscription line. The fund can only allow redemptions on extraordinary circumstances. Again, for your typical closed-end fund, that is not an issue. So if you can rely on the venture capital advisor exemption, then you're put in a similar situation as an advisor relying on the private fund advisor exemption. That means you're an exempt reporting advisor. So again, you're making a Form ADV filing within 60 days of relying on the exemption. You have to update that annually. You're subject to SEC or potential SEC examination. You're subject to the SEC pay-to-play rule with respect to soliciting U.S. government entities, and you're subject to the General Advisors Act anti-fraud provisions. There are no limitations on the assets under management, so you can have and also place of business. So you can open up a U.S. place of business. You can manage as much money from that U.S. place of business as you want. You can raise as much money from U.S. investors as you want, so long as all of your clients and all the money is going into venture capital funds.
Thanks. So what if none of these exemptions are available, or what if you have a desire to open up an office in the United States that itself won't be able to rely on this exemption? What does that mean? Well, if an exemption is not available, you have to register under the Investment Advisors Act. Now, we won't go through all the mechanics of registration. Registration itself is fairly straightforward. You file something called a Form ADV with the SEC, and the SEC has 45 days to act on that Form ADV. And really, their only bases for denying registration is either if you haven't completed all the items in the form, if they conclude that you've been misleading in your responses, or if the advisor or certain of its personnel have been subject to certain disciplinary proceedings that provide the SEC with the basis for denying registration. But as a general matter, it's fairly straightforward and easy to become a registered investment advisor. There aren't any capital requirements. There aren't any licensure requirements in the sense of having some level of competence or training. So you can register, but what does that mean? Well, the Investment Advisors Act has been interpreted to impose a fiduciary duty on investment advisors. They're incorporated into the anti-fraud provisions of the Advisors Act, and basically those fiduciary duties require, among other things, that the advisor avoid conflicts of interest or fully disclose them to investors or to clients. The substantive provisions of the statute beyond that are fairly straightforward. There are some requirements as to certain terms that have to be included in written investment management agreements. Under SEC rules, there are also detailed record-keeping requirements, and there's administrative oversight by the SEC through periodic staff examinations. And the staff these days implies sort of risk-based metrics to identify advisors they want to register. There are also a number of rules that have been adopted, particularly over the last 15 years under the anti-fraud provisions that address, among other things, custody requirements for fund assets, political contributions, and the like. So there is a fairly detailed scheme of regulation under the Investment Advisors Act and fairly detailed books and records requirements. In most cases, non-U.S. advisors try and determine if they have to register, whether there's a way in which they can register an entity that will be registered with the SEC without registering the parent company or the European-based entity that conducts investment advisory operations. And there have been two ways to accomplish this. In other words, two ways to register a U.S. investment advisor but not register the European entity. The first approach, and I'll say as a practical matter, this approach is really not frequently followed because it's extremely cumbersome, is the so-called Richard Ellis approach. And that Richard Ellis refers to a no-action letter that was issued by the SEC in the 1980s that was designed to set up some guardrails for allowing foreign investment managers to set up U.S. registered entities. But the conditions for the Richard Ellis approach were fairly cumbersome in the sense that they impose structural requirements that are sometimes difficult to meet. The registered entity has to be adequately capitalized. A majority of its entities have to be independent from its parent company, or there has to be a similar buffer. It has to have employees who are engaged in the day-to-day business of providing investment advice. They have to formulate their own investment advice. In other words, they can't really be dependent on the parent company, and they have to keep the advice confidential until it's communicated to clients, and that would include from the parent company. A very cumbersome approach, and the SEC ultimately realized this in 1992 when the staff began to issue a series of no-action letters, often referred to as the Unibanco letters, that were basically designed to provide European or Asian money managers the ability to set up U.S. registered investment advisors that would be providing advice to U.S. persons. And basically, the Unibanco approach permits an advisor to do that subject to certain conditions that are designed to make sure that the SEC has access to the books and records and personnel of the parent company that would relate to the activities of the registered investment advisor. So this approach provides flexibility in the sense that it allows the U.S. registered entity to use the resources and personnel of the parent company to formulate and deliver investment advice. On the other hand, it does subject the parent company to a certain level of oversight from the SEC because the parent company has to, in effect, agree to make books and records and personnel available to the SEC in the event that the SEC wants to, as part of the SEC's examination program. And these undertakings are basically effected through something called a participating affiliate arrangement between the registered investment advisor and the parent company, where the parent company agrees to make these books and records available, to appoint the U.S. entity as its agent to accept service of process in the U.S. and so forth. And this approach seems to have worked reasonably well since it was initially adopted. There's another element of the Unibanco letter that is important particularly if a non-U.S. investment advisor that even if it doesn't have an office in the U.S., decides that it has sufficient contacts with U.S. clients as well as non-U.S. clients to warrant registration of the foreign entity. And under the Unibanco approach, the SEC concluded that many of the provisions of the Advisors Act should not apply to the registered investment advisor that has its principal place of business outside of the United States in connection with its dealings with its non-U.S. clients. So, for example, if that investment advisor is dealing with a U.S. client, the contract with the U.S. client would have to contain a provision that prevents the assignment of that contract without the consent of the client. It also, there's a provision of the Advisors Act that also prohibits charging performance-based fees. There are a number of exemptions from that prohibition that make it largely less of a factor for managing private funds. But in any event, if you are a non-U.S. based advisor and you're registered, you can have a performance fee with your individual clients who are not U.S. persons, even if they wouldn't be eligible for the exemptions from the performance fee prohibition. There are other requirements that similarly wouldn't be applicable. There are some disclosure requirements, requirements that the advisor deliver its brochure, which is basically akin to a prospectus for the investment advisor. You would have to deliver that brochure to U.S. clients. You wouldn't be required to deliver that brochure to non-U.S. clients. Similarly, the custody rule requirements of the Advisors Act would not apply to the foreign investment advisor's relationship with its non-U.S. clients. And the custody rule, we'll just say, we won't go into the details of what that entails, but it's among the most complicated rules under the Advisors Act. So if you wind up in a situation where the non-U.S. based manager has to register, it may be that many of the most onerous requirements of the Advisors Act, including the custody rule, won't apply to that foreign advisor's relationship with its non-U.S. clients. Before we turn to the scenarios, I think Greg will touch on some of the other regulatory issues that you should be aware of if you begin to focus on raising funds from U.S. investors or open an office in the U.S.
Right.
Maybe,
so
sorry for interrupting. One point someone from our audience took up was the question, when you are relying on the private placement exemption, does it then matter whether when you do a press release, whether this is available like online in the US or whether you only do it in print outside the US?
So if the press release relates to the final closing of the private placement, in other words, you're not going to be doing any further marketing, then it wouldn't be viewed as a general solicitation at that point because the offering is completed. If you want to do an interim press release, say announcing the first closing, you clearly couldn't do that in the U.S. And I think the question would be whether a press release that's issued outside the United States could reasonably be expected to be disseminated in the U.S., or even whether that press release itself would be viewed as a general solicitation for an offering that's relying on 506D. So it may be that in the circumstances you describe, you may have a separate fund that's relying on Regulation S, where there's no general solicitation limitation, and then a judgment would have to be made as to whether that press release, if it becomes available in the U.S., would be viewed as a general solicitation for purposes of the offering of the fund that's relying on 506D. So it is a complicated issue, and I don't think you can simply rely on the fact that the press release was issued outside of the United States or even in a language other than English to get comfortable that that might not be viewed as a general solicitation. Greg, I don't know if you have any.
No.
Okay.
Thank you.
I think we're getting close to the end of, before Greg goes into the other regulatory issues, are there any other questions? Okay, Greg, why don't you go ahead?
Yeah, so just to go quickly so we can get to the scenarios, we just listed out a few of the other regulatory issues you'll consider if you're a private fund. The Commodity Exchange Act, which will cover entities that are trading in commodities. Usually your private equity fund or your venture capital fund can rely on exemptions under this, but you'll want to make sure that you're within that those exemptions. But if you're a hedge fund, you may not be able to rely on those exemptions. There are various state law issues that may come up, but usually not if you follow the traditional structure we kind of laid out before. The broker registration, broker-dealer registration exemption is very important. I think usually if you are going to market in the U.S., you should be careful about the people you hire. The people you hire generally should be U.S. registered broker-dealers. There might be limited circumstances where they don't have to be, but usually you should be hiring a U.S. registered broker-dealer to solicit people in the U.S. But also if you open an office in the U.S. that's, say, a group of people that are solely dedicated to raising money from the U.S., you'll want to determine whether they can rely on an exemption or if they have to register as brokers as well. That's a very important issue. The last two we're not going to cover in a lot of detail. It's the Volcker Rule and ERISA. Volcker Rule mostly relates to the ability to solicit U.S. and non-U.S. banking entities. There are generally exemptions for most non-U.S. banking entities to be able to make investments now. ERISA relates to retirement plans and pension plans, and there's various restrictions on that that you should be aware of. But usually you'll get advice from U.S. counsel as to making sure those aren't applicable.
And the key point being that you should make sure your U.S. counsel considers ERISA issues before you make the determination to raise a substantial amount of money from private U.S. Pension plans. State and local government pension plans aren't covered by ERISA, but they will often, on their own, adopt ERISA-type limitations that are really designed to limit affiliated transactions and other types of conflicts of interest. Let's turn to the scenario analyses. In the first scenario, you have a manager or sponsor that's based in the U.S. and they are seeking investors in Germany. They're doing so through a private equity or venture capital fund, and this is pretty straightforward. You have a manager in the U.S. and the manager will have to register as an investment advisor unless an exemption is available. In this case, it may be that the exemption would be the venture capital fund if the manager is going to basically only be raising a fund that satisfies the venture capital fund exemption. But if it's a private equity fund, the private equity fund exemption would only be available if they're raising less than $150 million from investors in Germany and other places in the United States. So they may have to register as investment advisors. The actual offering of the fund may be able to rely on Regulation S under the Securities Act, but we're assuming here that the fund itself would not be organized under U.S. law, that it would be organized in whatever jurisdiction is appealing to German investors. That would mean that there wouldn't really be any Investment Company Act implications for that foreign fund. So it wouldn't have to limit its investors to qualified purchasers. It wouldn't have to. It could engage in general solicitations. The key point, though, is that the investors are not going to be U.S. persons. Greg, why don't you go through the next scenario?
Yeah. So the next scenario is essentially the same scenario, but now with the investors in the U.S. And as Ken was alluding to, that changes the analysis both from the Investment Company Act side, but also from the Securities Act side. So now that the fund, even though it's a non-U.S. fund offering back into the U.S., you now have to worry about the Investment Company Act, in particular that the U.S. investors, either you have fewer than 100 U.S. investors, or all of your U.S. investors are qualified purchasers. And also for that offering back into the U.S., it's going to have to rely on usually Regulation D or one of the private placement exemptions here. We're presuming Rule 506. So that means all those U.S. investors have to be accredited investors as well. The Advised Act analysis is essentially the same as the prior one, and it would likely have to register unless it's either a venture capital fund or less than 150 million.
Yeah, and that, by the way, the venture capital fund exemption is why we have the box designated portfolio on the chart, because again, if you're focusing on a venture capital fund as opposed to a private equity fund, then the composition of the portfolio is going to be very important for the reasons that Greg described earlier in the seminar. To rely on the venture capital fund exemption, the actual fund itself has to be limited to certain types of investments. In the next scenario, the manager or sponsor is based in Germany. Again, it's a PE or venture capital fund that we'll assume is organized outside of the United States. But the investors are all going to be U.S. persons, or that's the anticipation. What are the issues here? Well, since it doesn't differ that much from the prior slide, there are Investment Company Act considerations because the investors are in the U.S. So regardless of what jurisdiction the fund is organized under, the investors, either you're going to have to limit the fundraising to basically 100 U.S. investors if you're relying on 3C1, or U.S. investors who are qualified purchasers if you're relying on 3C7, or both exemptions if you're going to set up two funds to be made available to U.S. investors. The offering will have to be a private placement for purposes of the 1933 Act, so it will probably be relying on 506, 506B. The manager or sponsor, because it's based outside of the United States, may be able to rely on the private fund advisor exemption, because presumably all of the funds would be managed from an office outside of the United States. Alternatively, if the fund is being structured as a venture capital fund, the manager may be able to rely on that exemption.
So the next scenario is basically you place everything outside the U.S. or at least in Germany. So the manager is based in Germany. You're raising only money from German investors or European investors, at least non-U.S. investors, and the fund is organized outside the U.S. So this is but you're investing back into the U.S. Say you're a venture capital fund investing in U.S. Companies, or a private equity company investing in U.S. companies. So the Investment Company Act and Securities Act analysis is the same as before. Again, I should say different because it's no longer offering to any U.S. investors. So you're not making an offering to U.S. investors. So there's no Securities Act implications. And it's organized outside the U.S. and also offering only to U.S. investors. So there's no Investment Company Act applicable. The manager, here presuming the manager is outside the U.S. and doesn't have any U.S. place of business, there's no Advised Act implications. They can rely on the foreign private advisor exemption because they don't have any U.S. clients and they're not raising any money from the U.S. investors, so there's no issue there. So essentially, you can do all of this and you can invest into the U.S. Without raising any implications under the any of the U.S. federal securities laws. So you can make investments in the U.S. without having to register anything.
Yeah, this next scenario is really designed to illustrate the operation of either the Richard Ellis letter or the Unibanco letter. I'm sorry, we're having a problem with the slide. And the scenario contemplates that you'll have a U.S. manager, you'll have a German manager that sets up a separate entity in the U.S. To engage in certain activities. And it's also conceivable that that U.S. manager or sponsor or entity might have a role in managing the funds. Now, one approach would be to try and structure this in a way that satisfies the Richard Ellis conditions in which case while the U.S. entity may have to register, the manager, the German manager, would be outside of registration. But as we said, that's fairly cumbersome. But if you satisfy the unibanco criteria, in other words, you set up the U.S. registered entity and enter into participating affiliate agreements with the manager, while the U.S. entity will either register or determine that it may be subject to another exemption from registration, the manager would not be required to register, but would be required to provide books and records and personnel to the SEC in the event of an examination. The U.S. entity would, to the extent that its activities were sufficiently limited to advising a private fund and didn't manage more than 150 million of that private fund's assets, or in the alternative was limited to managing a VC fund, may be able to rely on an exemption, but it may also be required to register because those exemptions wouldn't be available. Would also note that, again, we weren't going to focus on broker-dealer issues, but if that U.S. entity is involved in soliciting investors, whether or not those investors are in the United States, because that entity is based in the United States, a determination would have to be made as to whether that entity or its personnel need to register as brokers, or in the alternative, whether they can rely on the exemption for issuers that was mentioned in an earlier slide.
So the next scenario relates to basically if you set up a feeder fund to come into a U.S. fund, and just the short answer is you're going to have to look through the feeder fund. So it's essentially as if the German investors are coming right into that PE fund or venture capital fund in the U.S. So that means all the German investors have to be qualified purchasers, or you have to have less than 100 investors in the main fund looking through any feeder funds into the main fund. I think just the point here is, while there might be tax reasons to set up the feeder fund, from an investment company act perspective, you'd be looking through any feeder funds when you're determining the status of the main fund and what exemption it can rely on.
And this final slide, I think, is just intended to illustrate another scenario where you have U.S. investors and non-U.S. investors investing in the same fund. There may be a number of reasons why a European manager would want to establish the structure in order to source U.S. investors and accommodate their tax planning needs. By the way, neither Greg nor I are tax lawyers, so we can't really address this. But the challenge here would be in making sure that the funds or fund that was organized to raise money from both categories of investors satisfied both the Investment Company Act requirements, so that if it's an offshore fund, the U.S. investors are limited to qualified purchasers, for example, if it's relying on 3C7, as well as making sure that the offering to European investors satisfy the conditions of Regulation S, so that, in effect, you can have a fund making two offerings, one of which relies on the private placement exemption, the other of which relies on Regulation S. Again, this course is available if the fund is organized in a non-U.S. jurisdiction. With that, our presentation is complete. If you have any questions, even though we're I think a little bit past the time, we'd be happy to answer them.
I've been checking the question that came in here, and I think we covered most of the ones that were related to that. One is a bit outside of the scope, but still important. As we introduced, many are doing investments in the US, and one participant asked whether what applies if they themselves are doing investments in the US, and in that scene, or in that timing of doing an investment, also try to help to support the portfolio company finding other investors. Whether this is a regulated activity, I don't think we should go into too much detail, but maybe you can give a few bullet points what you would have to look into at such scenario.
Well, I think the key bullet point would be whether, in connection with the assisting the portfolio company in fundraising, whether that would trigger any broker-dealer registration concerns. So that person probably wouldn't be able to rely on the issuer exemption, Rule 3A4 under the Exchange Act, although that would certainly be something that should be looked into. If that person was actually being compensated for his or her fundraising efforts, that would clearly raise a broker-dealer issue. Mm-hmm. Again, I don't think it would raise Investment Company Act issues. It wouldn't raise Investment Advisors Act issues. They would obviously, if they're seeking to raise money privately, want to make sure that their efforts don't trigger any Securities Act registration requirements. But I think the primary issue would be broker-dealer registration.
Yeah, and to that point, any sort of success fee, transaction fee, something percentage of the amount of money raised would be, I think, the biggest red flag of an issue of broker-dealer registration. On the first one, I didn't quite, it was just investments in the U.S. Usually, personal investments in the U.S. aren't regulated other than the fact that the funds and, investment advisors and other people have regulations on what they can, the types of investors who are allowed to come into various entities. So they wouldn't be directly registered or regulated by investing in, but they might be impacted by the regulations.
And in giving that response, we're assuming that it's a private company. So if the person is making a substantial investment in a public company, and let's assume that it's a small public company, there may be, if they wind up owning more than 5% or 10% of the outstanding equity securities of that company, there may be filing requirements under the 34 Act that are designed to put the market on notice that there's a substantial security owner, but typically that wouldn't be the case. And in the case of a private company, it wouldn't be the case at all.
Thank you very much for answering this question. I think we have one final question. Let's do this as a final question. Georg asked whether if he has been introduced to an investor for his first fund through a broker-dealer and then is doing his fundraising for the second or third fund, do he has to go through a broker-dealer again, or is can he just make use of the scenarios we described earlier in this webinar?
If the fund and its manager are in a position to rely on that exemptive rule I referred to, Rule 3A4 under the Exchange Act, which is basically a safe harbor rule that's available to issuers, and in the case of a fund, its general partner, then it may not be necessary to go through a broker-dealer if you satisfy all the conditions of that rule. Okay. Again, the use of a broker or placement agent is often an important element in marketing to U.S. investors. They understand the market. They have contact with various investors. One question would be to look at the engagement letter for that initial offering to make sure that they don't have any obligations to go back to that broker for future fundraising and future funds. But from a regulatory perspective, if that second fund falls within Rule 3A4, then they shouldn't have to be concerned about that.
Super. Thank you very much. That was very, very interesting, and I think we all understood that there's a lot to be looked into, a lot of different scenarios, but there are possibilities. And in particular, what I found interesting, or what is always interesting when things move throughout the lifetime of a fund, then also, of course, you have to reconsider your position. So if your exposure to the US increases, even though at first you didn't need an Advisors Act in registration, this can come through the term of the fund. So I think it's always important that you closely check when things change. So thank you very much, Ken and Greg. That was very interesting, and thank you to all the audience for participating.
Okay. Thank you, Fabian. Thank you to everyone.